Right, we will proceed then to listen to the passages which you identified, and I think in order.
Yes, my lord.
I should start with just.
My lord, the first passage we will have to go to would be at the top of the page 1117, and it is
414. Yes.
Yes, page 414, and it is on the tape 1 hour, 17 minutes, 41 seconds.
It actually starts 413, doesn't it, the paragraph? But anyway, don't alter what you set up.
Person in those circumstances to suggest that there should be a proper identification parade is a parody, a sham. And I'm not prepared to tell you, ladies and gentlemen, that you should ignore the testimony of witness leading in view of the absence of a proper identification parade. Had there been an identification parade, submission would still be made.
Can we just start a little earlier than that? I would start, if you can go back a page, to where it begins, somewhere like Learned Counsel for accused number 3 and 4 on page 413.
Yeah.
Somewhere a page earlier.
Yep, page 413.
This is dealing with an identity. Have you got it?
That would probably be 1.1415, around there. 116, yes.
Look back in your skeleton at the table.
Thank you, my lord. Thank you, my lord.
116.10 or thereabouts.
Right. So 116.
116.10.
1610.
116.
116.
116.10.
Should be anyway.
Details and not the central issue, the material fact, which is more important. And as to 3, there's a confusion in the mind of counsel. Witness Topsy was referring to the third car, which was pushed from the direction of Lymin, while witness Litting was referring to his car. And I shall come back to that again when Mr. Mohammed has submitted. Learned Counsel for accused number 3 and 4 further submitted that the accused were deprived of a proper identification parade. Remember that it was through no fault of the police who accused that an identification parade could not be held. It was only at the 11th hour that Mr. Litting, in a statement, stated that he had identified accused number 3 and 4 on 2 occasions. On the first occasion, he was at the Disco to Police. Accused number 3 and 4 were not alone. There were 9 of them. And Mr. Litting said he immediately recognized the tall guy of fair complexion to whom he had asked to steer his car and who jeered at him. The shorter guy who had smashed the rear window screen and the window on the side of the driver's seat before setting it ablaze with petrol. The second time was last week, of course, before he deponed, when he was waiting in court number 4. He again recognized those 2 persons in those circumstances to suggest that there should be a proper identification parade is a parody, a sham. And I'm not prepared to tell you, ladies and gentlemen, that you should ignore the testimony of witness Litting in view of the absence of a proper identification parade. Had there been an identification parade, submission would still be made that it would be unfair as the accused had been seen in court. It all boils down to a question of whether the witness would be able to recognize the accused.
Yes, my lord? May I just...
You want any more?
No, that's it.
No,
That's
thank
for
you.
the
Yes.
first passage, my lord. And what I would comment on this, my lord, my first remark, if I may, my lord, this is not a usual, measured, impassionate tone. That's the first thing I would... At this stage, my lord, the judge emphasizes 3 words: parody, sham, and ignore. The reason for the emphasis on those 3 words is to bring about a clear direction and ask a jury to find there was no need for an identification parade, when the whole of the tone used in that passage is dismissive of the appellant's submission as regards to the identification parade, as in fact the appellate court found that those submissions were correct and the directions were irregular, in fact, my lords. The judge then buttressed immediately his own finding by stating a hypothetical surmise of what the appellant's submissions would have been if ever there had been an identification parade.
Right.
The tone used, my lord, is to show that even in this hypothetical surmise, the appellant's counsel would again have got it wrong and would again have made wrong submissions in law, clearly establishing a hierarchy between good submissions made rightly by the prosecution and bad submissions made wrongly by the defense. I need not refer your lordships to paragraph 62 and the table 211 at page 1113, which has been fully adumbrated when you hear all those passages after having heard over 5 times that the prosecution is making right submission and the tone is dismissive of defense counsel submissions, my lord. What, my lord, would one expect a jury to do? That is the point I want to do.
Right.
The next issue, my lord, is at pages 423 to 428, and this should be, the whole passage should be read, where the learned trial judge is dealing with the defense submissions in turn, the A to M. That is at 1 hour 36.29 seconds to 1 hour 45.46. And if you can listen to the whole passage.
In the end, stood the test of cross-examination and have deposed in a straightforward manner on the essential issue, namely what happened at L'Amical on the night of May 23rd, 1999. Remember, Mr. Mohammed SC, I referred to the following matter in his submission to invite you not to believe the witness. A. That the police inquiry was unfair, as the alibi accused number 1 and 2 were not even checked. The times of closing were not secured for forensic analysis. No statement was recorded from witness Renaud Zamir who had seen the red. Ladies and gentlemen, I had already given you an indication of how you should deal with that issue. I need not repeat myself for that. The evidence of witness Timol, the scientific technology showed that there was no evidence to connect the red car with the fire at L'Amical. For your guidance, that finding is not probative that the car was not at Royal Road. That the fact of simply throwing stone could not make that person a co-author. I have dealt lengthily with that when directing you on the question of co-author. Witness Azat Tepsi, being a self-confessed perjurer, counsel said, would fabricate evidence. His evidence must be corroborated. Available corroborative evidence was not assured. I have already directed you on this point. You may act on the uncorroborated evidence if you feel certain that is a credible witness after giving you the necessary warning. Witness Tepsi lied when he said that he had told the inquiring officer in respect of the sequestration charge that he did tell the inquiring officer that he mentioned the names of the parents of the Sumodhee in relation to the Keramuth episode. What does the record show? It shows that the witness stated that he did not mention it in the statement of the 25th of October 2000, but that he did so in his statement relating to the sequestration. When he was pressed further, why he did not say so in the statement on the 25th of 2000, as he was prepared to speak the truth, the reply was that it was already in the statement relating to the sequestration case. Later on, counsel himself conceded that the witness did mention the Keramuth episode in the statement of June 14, 1999. Then counsel questioned him whether he did mention Keramuth during the sequestration trial, to which he replied, I do not recall. The matter rested there. Then Corporal Bislam was recalled, and he stated that the witness never mentioned the parents of accused number 1 and 2. In the light of the above, it is clear that the witness was never confronted with that statement, and he was not given an opportunity to explain. The next point taken was that he lied to the police when he said that he had not been to Line Barracks with counsel as Mohammed and then to the journalist, Mr. Abel, and his explanation in court, and that explanation in court was not convincing. Remember that Inspector Badal conceded that he made a mistake as to the date, for it was agreed that Thursday was not the 11th but the 10th. Since in the statement, Inspector Badal put to the witness what he had said, if Kisner had stated that on Thursday 11th, 1999, they went to those places, his reply is correct. But then, the witness stated that in fact he did tell the inspector that he did go to those places, and the inspector denied. Since the witness had accepted on the oath that he had been to those places, what would be in the statement would be incorrect. I do not consider that much issue should be made out of that. Witness Topsy had an interest of his own to serve in giving evidence against accused number 1 and 2. Therefore, had been induced, and that was to gratify the police, and he had a grudge against accused number 1 and 2. And he waited for 17 months, and it was only on the eve of the marriage he decided to tell the truth. In fact, what had prompted him to go to the police, according to the evidence and the cross-examination, was that he could not stand the pressure anymore and gave other reasons, to which I shall touch in later on. The various contradictions, namely, whether the crowd went to 2 Street, as stated by P.S. Hosseini to Defoe Street, where the car was parked when he reached Cathedral Square, the number of people in the car at Gaddafi Square compared to what P.S. Hosseini had seen, the contradiction as to the words uttered by the witness, qui se piatan à nous al-Khaza Mefa, when P.S. Hosseini said, nous al-Chancellor House, nous al-Khaza Mefa. As to the first point, if you believe in the Tafsir that he did follow the crowd, his testimony will be more reliable than the police sergeant, who stated that, in quote, that from where he was standing, he could not see well, although he said something else in his statement. It is correct that both witnesses did not say the same thing. You must be guided by the fact that the power observation of both witnesses are not the same. And furthermore, as there was a huge crowd, the description would depend on the field of vision and whether there was obstruction. Witness Tipsy said his vision was obstructed. In substance, both witnesses had said, nous al-Khaza Mefa. The fact that one has had Kizupiat and the other one as well, nous al-Chancellor House, should not render their testimony unreliable. Where witness Tapsi was standing at the corner Wall Road, MIS Arcati Street, in the photo, and where there was a noisy crowd, where they could hear accused number 1 saying, "How those cocktail Molotov on the first floor of L'Amical." I leave it to your appreciation of whether, despite the noise, he could have heard those words being uttered. Mr. Mohammed said that the sequestration was strange. At the hotel, the keys were with the Tapsi brothers, and that they even phoned to the mother at Albion. The brother left the bungalow to visit his fiancée, and witness Topsy went swimming on two occasions, and on Saturday they played cards all throughout the night. We not considered what counsel had pointed out. He agreed to that. And the witness told you that all his movements were watched, followed. Therefore, it was for you to decide whether you believe him or not on this point. But before the paper came out, they went in hiding from the CID, not to get them, and yet the affidavit was never sold. The evidence was that they had to be together until the affidavit was sold. It is for you to appreciate whether the suggestion of counsel is right, that they were to hide from the police. That witness Topsy had lied for 4 months straight under oath to the journalist, to Mr. Viaden, and whether he could be believed. The witness admitted that he had lied and that he was compelled to hide the truth as he was under compulsion. I leave it to you to consider whether you accept his explanation. The witness Topsy mentioned that he saw accused number 4 pouring petrol on a car, and accused number 1 asked for matches, which the crowd handed, and all 4 accused destroyed the match to set fire to that car. Whereas witness Litting never mentioned accused number 1 and 2, and said it was accused number 3 who set fire to the car. There was therefore contradiction, and whether witness Litting was telling a lie then. From the record, there's a confusion in the mind of counsel. As rightly pointed out by Mr. Boulel, Mr. Litting was referring to his car, which was set on fire by accused number 2, while witness Topsy was referring to the car which was parked near Paris Studio and which was overturned and heaved to the other side of the road closer to L'Amical, where the car of witness Litting was. That witness Topsy did not mention the use of iron bar to hit the car, or the use of a pole to heave the car or to overturn, whereas witness Litting did remember that it was never put to witness Topsy. So I have mentioned one by one.
My Lord, again, the tone is anything but fair and normal in this passage we've heard, my Lord.
Can I just ask a question to that? I mean, the judge, I'm not sure whether the volume is right here, but he clearly put matters quite strongly and sometimes abruptly, but may that not be typical of the whole summing up? He doesn't seem to alter tone in
My
these
Lord,
passages.
I would answer your Lordship by saying that in choosing to descend into the arena, this is in effect what the learned judge was doing. He was descending in the arena. He was bound to exercise more caution in the use of the tone.
The arena, he was just addressing them in quite a forceful way, but which bits do you say descend into the arena?
My Lord, for example, I can immediately...
I reference to their tone, really. We can read the transcript.
Yes, my Lord, if you go first to that passage where he says, there you are, somebody who is a perjurer. His evidence is to be believed over a police sergeant. That is a matter for the jury. That Mr. Topsy's evidence is more reliable on that account than that of the police sergeant Oseni. That is page 426 at line 8.
Yes, I see.
If you believe witness Topsy that he did follow the crowd, his testimony would be more reliable because of the standpoint. But he's not saying you must believe him. You just say, if you believe what he did, then he was in a better position to observe. I think that's all that's saying.
Okay. But, my lords, here, if you would have in the staccato, one may say, he adopts and renders, it gives a bellicose impression to the jury. And my submission is that would your lordships not agree with the appellants that such a tone was inappropriate in the circumstances of the case.
Do we gather from that that this is much the same tone as the judge used throughout, but your point is that he should have modified it
Yes,
while he was dealing with the defence arguments?
precisely, my
Is
lord.
that it?
It is that, my lord, especially when what we have to bear in mind, my lords, is the whole issue dependent on the version of two witnesses. And the credibility of those two witnesses were an issue before the jury. Little and witness Topsy. Witness Topsy in regards of all four accused, and witness Little in regards of the last two appellants. So, to that extent, my lord, to give any indication to the jury that one may believe that witness or not, but the language used would seem, I mean, it's not the content, my lord, it's the way the tone, the way it is aiming at the jury, would impress on their mind, my lord, that there is only one way to go, convict. And they did so very quickly, my lord, within less than 2 hours, including their lunchtime.
But if the whole summing up was in the same tone, which you might describe as slightly bellicose, but that's not necessarily directed anywhere, it's just the judge's way of expressing himself, how can one conclude that the jury took any particular part of it as directed to the
My lord, the
defendants?
My lord, precisely the fact that we do not know, but I presume...
But why should they? I mean, here you have a judge who speaks in a rather staccato way, and it comes out, but it seems to come out continuously in quite a staccato way. Why should the jury take that as anything but the judge's mannerism?
My lord, if you do have the opportunity to go over it again, that passage, you will see the change of tone. It's not always that he's using that staccato approach, but see when he talks about defense counsel, where he emphasized, quite strange, Mr. Mohammed, for the sequestration part, and immediately to go after, as rightly pointed out by the DPP. I mean, these are matters where you're talking on the credibility of two witnesses, which the defense is putting in issue.
And give me, Mr. Bramden.
Yes, ma'am.
The bit that you've just pointed out is the top of 427, isn't it?
That bit I just pointed out to you, my lord.
Strange.
Yes.
What are you saying that is wrong? I want to understand it.
The emphasis on in the tone on that word strange.
But what did that convey to the jury?
Well, that Mr. Mohammed's theory is wrong.
Oh, that Mr. Mohammed's was strange, but that's not what he's saying.
No, Mr. Mohammed's theory was wrong.
But that's not what he's saying. He's saying that Mr. Mohammed was asserting that the sequestration was strange.
Yes. So...
All right, well, there we are.
The judge, you say, is casting doubt on that. Right?
Right, my lord. Then the next passage I would ask your lordship to pay attention to is page 429, volume 1, lines 11 to 16, 147 to 111. I think it can be run through with the fourth passage because they are closely together. So we can listen to both at the same time. That would achieve the purpose. Thank you, my lord.
So just begin a little earlier than 1.47.11.
Is it the X?
It's at page 429, my lord.
Ideally, we could do with starting with, ladies and gentlemen, you've seen and heard the witness Thupsi, but...
Yep.
Actually, just try and go back a paragraph. Probably a few seconds.
Really following on, isn't it?
Yeah. Go to 1.46, perhaps 30.
Remember that it was only at the start of his testimony that he was granted immunity from prosecution, a fact that he was not aware on the October 25th when he decided to give another statement to the police to say that, speak the truth. So what is that axe which Windows as a autopsy had to grind? It was not to gratify the police in testifying for the prosecution. He came out in court, he had enough, pressure was too much, he cannot sleep. he had lost so many jobs. He said the truth must come out, and he was getting married. The axe which he had to grind was, in fact, he would like to live with his wife and nothing more. That was the added motive which pushed him to speak the truth. Would you believe, as suggested by Mr. Mohamed Assi for the defense, that witness Azad Topsi, a most unreliable witness, not an angel, had implicated accused number one only after he had been assaulted by the police, as the witness had said on so many occasions under oath in different forums? Would you believe that witness Azad Topsi had lied to implicate the two accused simply to gratify the prosecution, as he was afraid of the imprisonment that he would face in respect of the perjury case, which was called on merit on the 30th of October? Or that he had a grudge against them because the incident when they were in the employment accused number 1 and 2. Would you believe that at the 11th hour, he decided to leave with the police? Remember the answer of the witness. He said he was there, had told the police what he saw, he threatened by the family of accused number 1 and 2, that they were sequestrated. Counsel imposed upon him that was shadowed was by one Kisnan. All the problems that he had encountered, he said, were due to his having mentioned the names of accused number 1 and 2 in his statement of June 2nd, 1999. Do you believe him? Are you satisfied, despite the various contradictions, that witness Azad Topsi is speaking the truth when he said that he saw accused number 1 and 2, hours and accused number 3 and 4, and described what each had done? Remember, Mr. Mohamed Assi had invited you to accept the testimony of Police Sergeant Hosseini, the NIU officer, who had noted the presence of the red Proton car 3211 October 96 at about 6 p.m. at the junction of Gaddafi Square and Bourbon Street. That the officer overheard somebody in the crowd where the red car was shouting words to the effect of mashing MFA. That evidence would confirm what witness Topsi had said as regards the presence of the car at 6 p.m. at corner of Gaddafi Square and Bourbon Street, but not as to the occupiers. However, witness Topsi went further in pinpointing that the person who shouted the words was accused number 1, and then the fourth passenger was accused number 2. Remember what Mr. Bulan has said. Both accused number 1 and 2 are no strangers to witness Azad Topsi, and consequently, there could be no question of mistaken identity or recognition if the testimony of witness Azad Topsi is accepted. In the end, it is for you, ladies and gentlemen, jury, to consider whether witness Azad Topsi is a credible witness on whose evidence you can act after giving yourself the warning of acting on an uncorroborated evidence of an accomplice, having in mind all the issues raised by counsel for the prosecution and counsel for the defense. Remember, I told you that I would help you to identify corroborative evidence which you could use in case you need independent evidence to buttress the unsatisfactory and not the unworthy or unreliable evidence of witness Azad Topsi. There are none. To complete the picture.
That's it. Now, in the first part, which I am going to address, which is at page 429, my lord, line 11 to 16, which start with the passage, what is that axe to grind? My lord, if you listen to the beginning of the passage, you'll see that there is a normal tone in the voice of the judge. But then it goes in crescendo. It exemplifies the manner in which you use short, pointed sentences delivered with their emphasis on the words. He had enough. Pressure was too much. He cannot sleep. He had lost so many jobs. He said the truth must come out. To leave the impression that witness Topsi, the tone there is to leave the impression that witness Topsi was credible and that the submission of the defense to the contrary effect were not correct. The pose that the judge observed.
Is that right? The next sentence,
Yes.
The judge goes on rather to downplay that, doesn't he? He says the axe which he had to grind was in fact he'd like to live with his wife and nothing more.
Yes, but
that
this
was
is...
the added motive which pushed him to speak the truth.
Yes, my lord.
That's all he was saying.
Yes, my lord. When you tell to the jury where the issue is credibility, that is the additional motive for him to speak the truth. What would come across to the jury? That he was speaking the truth. Therefore, this is the added motive for him to speak the truth. So,
in effect, you're saying that the judge was inviting the jury to consider whether he had any axe to grind.
yes,
And in fact, so far from having any ulterior motive, he was motivated solely by the consideration that he wanted to live with his wife, he'd lost his job, he was feeling pressure, and he wanted the truth to come out.
yes.
But this is surely this is to be read as an account of what Thrupsey was suggesting, isn't it? Are you suggesting that this is the judge telling the jury what to consider, as I suggest it, is really the judge
lord,
saying this was all he was suggesting?
My lord, I believe this is when he says the added motive for him to speak the truth can only convey it's the last nail in the coffin of the appellants.
But where does it come from? That's the question. Is this what Thupsey had said to the jury or not?
Well, my lord, if you look at the transcript of the evidence...
Well, you just tell us, Mr. Amber. We won't doubt you.
No. Insofar as the bit that he was going to get married and that he was under pressure, I think it is there. But whether he's lost his jobs, I've tried my best. Maybe the prosecution can help us. But I haven't seen that in the transcript.
Oh, I see.
I haven't seen that in the transcript, that bit which the judge refers. So I stand guided by the record, my lord. I haven't seen it myself, personally.
Did he give his evidence in English or?
Well, you have the translated version, my lord, I think.
Yes, we have. But I wondered in which he'd given it.
His evidence is in Creole,
Yes,
and translated at pages...
At the end of volume 2.
It is at the end of volume 2, I believe, my lord.
You're changing slightly the ground of attack, because this is a ground which doesn't depend on the tone of voice or anything. This is a pure transcript ground, isn't it? A misdirection if it's read as the judge's view.
Well,
rather than
the way he imparts it to the jury. My submission on this is that the only impression that tone can leave to the jurors is that Mr. Topsy is a credible witness who was speaking the truth, and there is the additional reason for him to speak the truth. Right? And insofar as the last bit I ask your lordships to refer to, which is at page... on the bit of there was no corroborative evidence available, that is at page 431. Again, my lord, one would say unsatisfactory, the choice of words, and not unworthy or unreliable. First of all, my lord, I know this is not part of the tone, but is that a matter for the judge to tell the jury?
But again, it depends how you read it, and
yes.
I can understand. I suggest, as I did before, that what he's saying is you might need corroborative evidence, it might be relevant if you were buttressing merely unsatisfactory evidence, but it wouldn't be relevant if you had already concluded the evidence was unworthy or unreliable. It wouldn't be relevant at all. And now your case is that that's not the only meaning, and certainly perhaps not the one which the jury might have attached. Yeah.
So that would...
I personally would like just to listen to the first two paragraphs, just starting on 146, but just a little bit earlier, and just going on for a very little. Where did you start before? Just start a bit earlier.
Page?
On page 429.
Thank you.
We can get back to ladies and gentlemen, you've seen and heard, witnessed Tupsy.
It is for you to decide if he's a truthful witness, or a témoin de complaisance to please the police. It is for you to consider if he was under compulsion of fear from threats received as explained by him. As at that date, he knew that he had to face the music in the perjury case. Remember that it was only at the start of his testimony that he was granted immunity from prosecution, a fact that he was not aware on the October 25th when he decided to give another statement to the police to say that, speak the truth. So what is that axe which witness as a Tupsy had to grind? It was not to gratify the police in testifying for the prosecution. He came out in court, he had enough, pressure was too much, he cannot sleep, he had lost so many jobs. He said the truth must come out, and he was getting married. The axe which he had to grind was, in fact, he would like to live with his wife and nothing more. That was the added motive which pushed him to speak the truth. Would you believe, as suggested by Mr. Mohamed Assi for the defense, that witness Azad Tupsy, a most unreliable witness, not an angel, had implicated accused number one only after he had been assaulted by the police, as the witness had said on so many occasions under oath in different forums? Would you believe that witness Azad Tupsy had lied to implicate the two accused simply to gratify the prosecution, as he was afraid of the imprisonment that he would face in respect of the perjury case, which was called on merit on the 30th of October? Or that he had a grudge against them because the incident when they were in the employment accused number 1 and 2. Would you believe that at the 11th hour, he decided to leave with the police? Remember the answer of the witness. He said he was there, had told the police what he saw, been threatened by the family of accused number 1 and 2, that they were sequestrated, counsel imposed upon him, that was shadowed was by one Kisnan. All the problems that he had encountered, he said, were due to his having mentioned the names of accused number 1 and 2 in his statement of June 2nd, 1999. Do you believe him? Are you satisfied, despite the various contradictions, that witness Azad Tupsy is speaking the truth when he said that he saw accused number 1 and 2, hours and accused number 3 and 4, and described what each had done?
There is one last matter which I would wish to bring your attention. If ever your lordships are with the appellants on this issue and you agree that one way or the others, matters have to be rectified, either by a reduction or allowing the conviction to be quashed, there is one person who was also accused along with the 3 appellants today. And I bring you to page 500, volume 2, immediately, my lord, who had also challenged his conviction. And I bring you to that part where he tried to raise the same issue about the tone.
Yes, and the Court of Appeal dismissed it
Court
out
of
of
Appeal
hand.
said, well, I don't care about your skeleton argument. I talked to you about this ground of appeal. And then it was not mentioned of tone. And knowing that the counsel for that person had joined in the motion, and you will see that at page 499, middle of the page, Mr. Padayachi submits.
Yes.
My lords, I am for appellant Nawu, together with my friend Mrs. Devuna. I join the submission of my friend Bakuri. and then is taken to task. It is in his skeleton argument, but the issue, all I'm saying, it is my duty, I believe, in the interest of justice, for all the persons to be treated likewise. So if you do intervene, a direction from your lordships in regard to that appellant would be useful in the circumstances as well, my lord. Unless I can be of any further help.
That is Mr. Nawar. Nawar.
Yes. Unless I can be of any further assistance, my lord, I believe I have completed my submission on behalf of all.
Could I ask a question, please?
Yes.
Mr. Ramburn,
Yes, my lord.
we have been concentrating, among other things, on page 431, line 12, where the judge tells the jury the unsatisfactory and not the unworthy or unreliable evidence of witness Azad Thupsi.
Yes.
With respect, are you entitled to take that point? It was ground 26 of the grounds of appeal, and if you have the substantive judgment to hand at page 711, you will see how the Court of Appeal dealt with it.
I would not be entitled, then, my lord.
I think not.
Thank you, my lord.
Right. Yes, thank you much. Mr. Hussain Bokkers.
No, I just endorse the submissions made by my learned friend in respect of that
very much.
as well. Thank you, my lords.
Shall we rise again, or do we want to hear any more?
The director would like to make some submissions.
Yes.
Director.
Thank you, my lord. May I start by inviting your lordship to consider tab 28, the case of Blaise Lunkulu at paragraph 44. I read, my lord, paragraph 44. We have listened to the parts of the recording of the summing up to which our attention was directed, although the speed of delivery varied between various passages. We have been wholly unable to discern any sign that the judge adopted a dismissive tone of voice or choice of language that denigrated the defense arguments. It is useful for a judge to alter his tone, speed, and style of delivery during a summing up in order to maintain the jury's attention. There was no identifiable pattern which reveals that the judge used a particular and distinctive tone of voice when addressing issues and evidence raised by the defense. As set out, it was suggested to us that the bass tone of the summing up would be palpable when the audio record is played. We have not found that to be all the case. The judge's facial expression, we are not dealing here with facial expression. It is also I may say, as a general principle, every judge has his own style. His summing up is imbued with his own personality. And I would humbly submit that it would be extraordinary, having listened to the tone that was used, which is the same throughout, that this tone on its own, even when combined with the manner he says it, would have left the jury with no choice other than to convict. All that I'm saying is that it was a 2-hour summing up by the presiding judge, dealing exhaustively with all the issues that emerged in that case, and the judge took the pain to lay out the factual aspects of the case and then to refer to the competing submissions of counsel. I humbly submit, my lord, that there was nothing objectionable, unfair in the manner in which he went about delivering the summing up. There were instances where he had asked rhetorical questions, but every time he had made those points, he also reminded the jury that it was for them and only for them to decide on these issues. I'll take the first passage, which deal with at page 404. Page 404 is the volume 1, my lord.
404.
404, I'm sorry, ma'am.
That's not part of what we had to look at, is it?
Yes.
All right.
Well, I don't think it's part of the passage relied on. This is the first passage in paragraph 68, but
yes.
It hasn't been relied on.
Fine. Can I go to the 9 minutes then?
Yes. The first passage relied on was 414, the parody sham, the identification parade.
My lord, the judge is entitled, as per section 50 of the Courts Act, which is found at tab 16, page 1320, to sum up the whole case to the jury, stating where the main questions and principle lies, and comment on the evidence and afford such explanations as he thinks necessary, as long as, obviously, he does not show any partiality on the one side or another. Section 50, tab 16, page 1320, also state that the presiding judge can state his opinion on any matter of law arising on the evidence. There is nothing unfair in the judge saying, well, that the question of identification in the way the evidence had presented itself, in that this witness had identified the two defendants then in the vicinity of the court, that it would not have led to anywhere if an identification period was...
No, but you're dealing with the substance of the complaint, which has been dealt with in the Court of Appeal and is not before us. We're concerned with the question whether there's anything in the tone or way in which the point is put, which is irregular.
In one sentence, my humble assumption, there's nothing objectionable about the tone there, my lord. Even with respect to the other passages, I see nothing untoward or unbecoming in the tone of the judge. I think it was balanced and fair, and there's nothing in the tone itself which could have influenced the jury to come to a biased verdict.
When the judge says to the jury, I do not consider that much issue should be made out of that, wouldn't it have been better to say, you may think that much issue should not be made out of that?
I fully endorse what your Lordship has just said. I think these are the odd sentences which could have been avoided, but it did not do any harm in the circumstances of the case. Unless your Lordship wants to have further submission on this is all I think.
Much. Mr. Rahman, anything in? No.
Thank you, my lord.
Thank you very much indeed. The board is grateful to counsel and will take time to consider its judgment, which will be handed down in the usual way. Thank you very much.
you can